real property, present estates and future interests. A person receiving rights to the land now receives a present interest. Someone receiving or potentially receiving rights to land in future is getting a future interest. There can be no gaps when the land is owned by nobody at all. In the US, land must be owned by someone all the time. There are three varieties of present estates: the fee simple, the fee tail, and the life estate. There are two if you consider that fee tail estates are now treated as fee simple absolute. Life estates provide possession until someone dies. So a life estate is always followed by a future interest. There are essentially 5 future interests. The first 3 are retained by the transferor. The other 2 are created in another, a transferee. When an owner conveys a vested estate smaller than the estate he owns, he retains a future interest called a reversion. For instance, if O holds real estate in fee simple absolute, but conveys merely a life estate to A, then O retains a conversion. When the transfer creates a fee simple determinable, the future interest retained is a possibility of reverter. For example, if O conveys land to L for as long as used as an orphanage, O retains a possibility of reverter. The right of entry arises when a transferor creates a fee simple subject to a condition subsequent. The reversion is freely transferable. At one time, limits were placed on the transferability of the possibility of reverter and right of entry during the holder's lifetime. Today, however, both of these interests are freely transferable. The future interests created in the transferee are the remainder, vested or contingent varieties, and the executory interest. A remainder is a future interest created in a transferee that is capable of becoming possessory on the natural termination of a prior estate created by the same instrument. A remainder could be vested, sure to follow, or it could be contingent upon a condition. An executory interest is a future interest created in the transferee that must cut short or divest another estate or interest in order to become a possessory estate. A future interest created in a transferee that does not follow a life estate or somehow does not qualify as remainder is an executory interest. It's traditional to distinguish between the shifting executory interest, one that divests the transferee, and the springing executory interest, one that divests the transferor. Fee simple absolute is the most common way real estate is owned in common law countries, and is ordinarily the most complete ownership interest that can be had in real property in the United States. Fee simple ownership represents absolute ownership of real property. It's limited by the certain government powers and by encumbrances such as easements, however. Fee simple absolute is created by words such as to Alice and her heirs. Heirs are the people that inherit from Alice if she dies without a will. As fee simple is the most common, perhaps default, form of estate, abbreviated language such as to Alice will today create a fee simple absolute. Any fee simple absolute lasts forever. A present interest that may not last forever is a fee simple defeasible. Of course, any fee simple defeasible creates a future interest. Upon defeat of the fee simple, property goes to another party, so that party must have a future interest of some sort. Fee simple absolute is the most common form of ownership. It's the default estate, and a grant that does not specifically create scenarios that terminate the fee simple or is ambiguous would usually be treated as a fee simple absolute. There are three different types of fee simple defeasible estates. A determinable estate is created when the grantor uses words such as until or so long as. For example, the grantor could state, I deed my land to John so long as he continues to feed my pets. In this situation, John has a present interest in the land until he stops feeding the pets. The time at which his estate is defeated is determined by the time that he ceases to feed the pets. When John stops feeding the pets, the state automatically, invisibly, transfers out of his ownership back to the grantor. The day that John fails to feed the pets, he is silently and invisibly converted from a landowner to a trespasser. Where the grantor uses the same language, states, I deed my land to John so long as he continues to feed my pets, but follows it with the grant to a third party. This creates a fee simple defeasible subject to executory interest. The language, I deed my land to John so long as he continues to feed my pets, then it goes to Anne, means that Anne has an executory interest in the land and will automatically, invisibly, silently become the owner when John stops feeding the pets. An estate subject to a condition subsequent generally is created using language such as on condition that or but if. For example, the grantor could state, I deed my ranch to Jane, but if my son Billy returns from abroad, the ranch is his. In this case, Jane has a present estate, the fee simple defeasible on condition subsequent. The subsequent condition is Billy returning from abroad. When Billy does return, Anne's estate does not terminate automatically. To gain ownership and terminate Jane's estate, Billy has to file lawsuit, re-enter the land, or initiate some action to assert his rights to own the ranch. Under the old common law, to Erica and the heirs of her body creates a fetail estate, an estate in Erica that passes to her descendants. The problem with this type of estate was that Erica's descendants could never sell the property. The property had to remain held by Erica's descendants. The solution, and the reason that the fetail estate no longer exists, is that these estates are now treated as fee simple absolute. The property no longer is bound to stay within the family, but is free to be sold by Erica or the heirs to which she passes the estate. A life estate is an estate for life. It lasts until the person identified dies. To Abby for life creates a life estate in Abby, then reverts back to the grantor when Abby dies. To Abby for life creates the measuring life in Abby. The estate expires when Abby dies. Abby can transfer her estate to Fred, but his estate terminates when Abby dies. The measuring life is not transferable. The life estate can be held by one person, but measured by the life of another. To Abby for the life of Fifi creates a life estate held by Abby. Fifi is the measuring life. Abby is the holder until Fifi's death. Then this estate reverts back to the grantor. The holder of the current estate, usually a life estate, is expected to pay the taxes on property, mortgage interest, and to keep the property in good condition. The future interest holder is expected to wait patiently until the present estate expires. The future interest holder is also liable for the principal on the mortgage. If the property is damaged, or its value is harmed by the actions or inactions of the present estate holder, the future interest holder can become very upset. Waste is a cause of action that can be used to remedy damage by forcing the current estate holder to pay the money damages to compensate for the harm that has been done to date. An injunction can be issued under the equity powers of the court to prevent future harm from taking place. There are various forms of waste. Permissive waste is where the current occupier allows the property to succumb to damage by weather and other forms of harm, usually through lack of maintenance and repair. Voluntary waste is where the current occupier deliberately damages the property. Financial waste is where the current occupier fails to pay taxes or mortgage interest, thus leaving a debt for the new occupier, the future interest holder. If the neighbourhood surrounding the property changes, and the current occupier or estate holder modifies the property, perhaps rebuilding it, then the present estate holder is not liable for waste, so long as the property value has been retained. Known as ameliorative waste, the property has been modified to reflect the changes in the neighbourhood, but the value has not been harmed as a result. The future interest holder cannot claim against the current estate holder, as they've really suffered no harm. Present and future interests form unique partnerships. A fee simple determinable leads to a possibility of reverter. The land can automatically revert back to the grantor. A fee simple subject to executory interest leads to an executory interest and can automatically pass to a third party when triggered. A fee simple on condition subsequent leads to a right of re-entry, under which a third party can take action to gain entry and assert their rights. The dead have limited rights under the laws of future interests. The rights of the deceased to control the distribution of their assets after death are restricted to a period of time. The period of time is measured by the life of a person alive and identified at the time of the grant. Beyond death, it's not possible to control one's real estate in perpetuity. The rule against perpetuities at common law invalidates certain future interests, traditionally contingent remainders and executory interests, that may vest beyond the time of perpetuities. In essence, the rule limits the testator's power to earmark gifts for remote descendants. The perpetuities period under the common law rule is not a fixed term of years. By its terms, the rule limits the period to at the latest 21 years after the death of the last identifiable living person at the time the interest was created. The period of the rule against perpetuities in donative transfers is 21 years after lives in being, the measuring lives, at the time the period of the rule begins to run. This measuring or validating life need not have been a purchaser or taker. The measuring life could be the grantor, a life tenant, a tenant for a term of years, or the person capable of producing members of a class of recipients. The rule prevents control by the dead hand. The property owner is prevented from distributing and controlling his assets for too long a period of time after his death. When a part of a grant or will violates the rule, only that portion is removed. All other parts that do not violate the rule remain valid. To Fred, so long as there are no slaughterhouses constructed on the land, then to Wilmer. This creates an executory interest in Wilmer that's void, as there's no limit to the time involved. If a slaughterhouse were constructed on the land in 200 years' time, it would be practically impossible to determine that this triggered the executory interest in Wilmer, who will herself be long dead at that point. Property with an ongoing executory interest such as this would be difficult to market, and the US real estate market would grind to a halt if the dead were able to exercise broad control over their land in perpetuity. To Fred, so long as there are no slaughterhouses constructed on the land, would be a valid grant. Fred would hold the property, but if a slaughterhouse were constructed, the property would revert back to the grantor. Of course, the grantor would likely be dead and the land would go to his heirs. The rule against perpetuities applies only to future interests held in third parties. It does not apply to a life estate or any present interests. A future interest retained by the grantor is not rendered void by the rule. So, the following future interests created in the transferee can be rendered void by the rule. Contingent remainders. Vested remainders are not perpetual, so they don't count. Remainders contingent on a condition can be rendered void by the rule against perpetuities, and so can executory interests. In fact, these are the most common target of the rule. Class gifts are also covered, where the gift is to a class of offspring or another group of individuals. Options and the rights of first refusal, typically to buy land, are also subject to the rule. They cannot continue in perpetuity. An option or right of first refusal that is open for more than 21 years is void. The life of the transferee does not measure the duration of an option or a right of first refusal, but it can usually be sold or assigned to another. So the 21-year clock starts measuring at the time the option is created. A 22-year option to buy land is not worth the paper it's written on. The exception here is where the option or right of first refusal is attached to a lease. A 22-year lease with an option to buy the land leased is valid. The 21-year clock does not start ticking until the lease expires. Charities have special treatment when it comes to the rule against perpetuities. If all the interests go to charities, then none of the charity's interests are rendered void by the rule against perpetuities. The law helps realtors stay in business by supporting the free flow of real estate transfers. When selling real estate, you can't prevent the buyer from subsequently alienating, which means selling, the real estate themselves. A restraint on alienation is a clause used in the conveyance of real property that seeks to prohibit the transferee from selling or otherwise transferring his interest in the property. Under the common law, such restraints are void as against public policy of allowing landowners to freely dispose of their property. Perhaps the ultimate restraint on alienation was the fee tail, a form of ownership which required that property be passed down in the same family from generation to generation, which has also been widely abolished today. However, certain reasonable restraints will be given effect in most jurisdictions. A restraint will be considered reasonable if it limits a few people from being able to buy the property, but does not restrict sale to members of the general public. A restraint that's limited in time will often be considered reasonable. So will a right of first refusal, allowing one buyer first rights to purchase when the property is sold. Restricting alienation of the property to charitable or public purposes will often be upheld by the courts. The public purpose of providing a park or facility for the use of the general population will often trump the public purpose of encouraging the free trade in real estate. Trusts are covered in more detail in a separate slideshow, but when dealing with real estate, it's important to remember that, like other property, real property can be placed in trust, both present possessory estates and future interests. When dealing with future interests, the question arises as to whether the rule against perpetuity is applied to trusts. The answer is yes and no. The rule applies to private trusts, but public, charitable trusts are once again exempt. A trust can be created by deed, declaration, will, or pour-over will, and a writing is usually required as the statute of frauds applies to private trusts. Public, charitable trusts once again have special treatment. Spendthrift clauses preventing the beneficiary from spending the trust funds too quickly, form restraints on alienation, as they restrict the free sale of the real estate. However, these are considered reasonable restraints on alienation and are usually upheld by the courts.